Good morning, everyone. I'm Leonard French, your favorite copyright attorney, and we're here for our weekly Sunday show, our Sunday service, as I like to call it. By the way, since I know everyone's going to ask, this is Angel Dust by AGST. Appears to be relatively new. I'll post a link to the YouTube version in chat, as well as a link to Epidemic Sound, where we are licensed to play it. Oh yeah, hat. Right, I always forget the hat when I get caught up in the trying to get everything ready for you guys. Split frame, I'm sorry to hear about the 360p. If there's anything I can do to help you, let me know. We're gonna output the VOD to YouTube, so you'll get to see it there if you couldn't see it here for some reason.
Yeah, I do believe there was issues on mobile. If you're in a browser, sometimes it doesn't let you load it up, so it's unfortunate.
So what's on today's show? Let's talk about a brief update in the Alex Malware case. We'll just talk about some of the things we already talked about on Friday's live stream, but we'll just reiterate them for anyone who missed it. Then we'll talk about the unconscious patient who died after doctors couldn't figure out what to do with his "Do Not Resuscitate" tattoo. Then we'll talk about the Martin Scully forfeiture. The government has asked the court to order him to turn over some very precious assets of his. We'll go over those documents. We'll cover the 3 documents that are involved with the Michael Flynn guilty plea. As you know, he pled guilty to lying to the FBI on Friday, and when he did so, he was represented by lawyers from the DC law firm of Covington and Burling. Now, I'm not too familiar with all these different law firms. I'm really not that kind of lawyer, but my sources tell me that Covington and Burling is a firm known for making deals like this plea deal, and that appears to be what Michael Flynn has done. So we're going to take a look at what's in the deal. We have 3 documents. We're going to cover them. By the way, I'm going to post a link to buy a copy of the audiobook or physical book for The Disaster Artist. This is the book that covers the making of the room and the basic disaster that it was. I didn't know any of this. I hadn't been part of this cult or culture for the last 15 years, and I just watched The Room yesterday, and now I kind of get it. It's hilariously bad. So we're gonna post a link. I posted a link to that, and that'll be in the whatever final description of the VOD that this thing comes out with.
Oh, hi, Mark.
Oh, hi, Mark. Yeah. She says I hit her. I didn't hit her. Oh, hi, Mark. What? He was like so distraught for one moment, and the next moment he's like totally relaxed about it. Hi, Mark. He says I hit her. I did not. It's so terrible.
So bad, yeah.
Yeah, so fortunately it's also only 84 minutes long, and while I'm not encouraging piracy, it appears that the easiest way to find it is just to do a Google search for it and find it on some website somewhere. So, yes, we could also talk about that. That's pretty cool. How about I bring that up here? I like that. This is a fairly big deal. Let's look at the 1 month, I guess. What do you think? We'll look at the 1 month. What do we think of this, guys? This is a little bit of Schadenfreude, right? Over the course of 3 months here, they went from $121, $118, and now we're down to $106, which is several percentage points. So while people may still be playing Battlefront 2 and all that, you did wipe out about $3 billion of EA's capital value. So good job on that. Hey, Camel Spit. Welcome. What? He says, I am awake. Set an alarm last week.
I'm right there with you, buddy.
Good job. Hey, it's hard to get up, man. Today was hard. Today, for some reason, was really hard to get up. I wanted to just keep sleeping and, like, just send y'all a notification that I was not feeling well or something. Even though I'm obviously feeling more or less fine. I'm just, like, it's a kind of a cold and dreary day, and yeah, what's 3 billion with stockholders, right?
But I do have the stream elements open, so whenever you want to stop between stories, I can read out stuff for you, and we have questions coming in as well. So
cool. Well, let's start with some of those. People have questions already. Let me bring the music down.
Sure. Nothing really serious.
Let's start with
just
some
yet. From Split Frame, who's your favorite indie musician?
Favorite indie musician was a band called Waltham out of Waltham, Massachusetts. There was also an artist. I'll continue. Waltham was more of like indie rock, like old school rock, and they were really great. So I highly recommend checking them out. And then there was a local artist around here, Groove Lily. I forget her name. I'm going to look it up real quick. But she and her husband were sort of writing like rock operas, but it was just 3 of them. She wrote Striking 12, which was I think a Christmas opera, a Little Midsummer Night's Music. Oh, her name's Val Vigoda. And she recently did a off-Broadway musical, which I remember talking about, but now I've totally forgotten its name. Let me see if I can look it up. No, I'm missing it. But I was a supporter of hers as well. Got my name in one of her albums and stuff for being a donor. Next. Any other comments or questions before I begin with our first story here?
Business asks, does my butt look good in these long johns?
Yes, your butt looks amazing in those long johns.
Rogue BFL asks, any update on the Bill Murray versus John Oliver case? Bob Murray versus John Oliver?
No, I was not able to immediately find anything. My news service only seems to cover federal cases, and the whatever West Virginia court that we're in, I believe everything's offline. I'm not sure that anything is online there at all. And so I think we're just waiting for news from someone to go to the courthouse and give us some news. And I'm not sure that there's anybody doing that.
And then
somebody let me know if there's news in that case, because I have no way of finding out. I'm going to learn about it through mainstream media.
Fair enough. And then one last question from Rogue BFL again. Any response from the judge about the rude email in regards to the Imigos case?
No, so let's start with that. The briefest of updates in the Alex Mauer case is that there hasn't been any response from the judge, and the information that I'm receiving on my end says that Alex may have intentionally been playing some sort of game. I got a copy of a text message that appears to be from Alex, but who knows? I can't trust things on the internet automatically these days. But it appears to say that she intentionally lied, hoping that the judge would invalidate the settlement and make us look bad. And instead, the judge went, "Okay, cool, this is done," and moved on. And so I think Alex might have been a little surprised that the judge didn't scrutinize things further. But as with most things in this lawsuit and claim, she completely misunderstands how things work. And she even had a lawyer available to her who could have explained all of this, and we could have had this over months ago, but it doesn't appear that she wants to have it over. She wants to use this for some kind of energy to feed something inside her. I don't know. It's a level of madness that I cannot comprehend. So, what Don and I came up with, I came up with the first half of this, and I didn't even think about the second half. I thought I was helping you guys when I included a bunch of language in the disparagement clause to include content creators, critics, affiliates, other affiliates, any affiliates, basically everybody who knows about Imagos in the situation. So, but was that going to be enforceable? Was a party who's not a signed party to the agreement really going to be able to go into a court and enforce that agreement against Alex? I don't really know. So then Don spontaneously just comes up with this, and he's like, well, why don't we just have them sign something that says they're an affiliate? Okay. So sometime early this week, I'm going to be putting something on my website as soon as I move the website over and get the SSL certificate up. And I have a little bit of technical work to do, but as soon as I get that done, we'll put up a portal for people to basically send an application, send us a bit of text saying who you are, what you do, what your link to your videos or whatever is, and then I'll have that auto-generate some kind of document. I'll still need to review it. It'll still be an arm's length transaction. It'll still be a real thing, not an automatic thing, because I got to make sure that Alex doesn't try to participate in this or something, right? But we'll get everyone who wants to be officially affiliated with Imagos without any pretense or anything. You don't have to like us or hate us or promise to make good videos or promise to make videos at all. Just if you want to be affiliated officially so that anything Alex does is covered by our settlement agreement, then you can become affiliated officially in writing. So that's what we're going to set up and figure out how to do sometime this week. So look for news about that on my YouTube channel, I guess. That's where that will appear. I'll definitely also put it up on Twitter and post it everywhere, so you'll hear me talking about it, but the major announcement with the official everything will be on YouTube. Really low volume? No, I'm showing that I'm actually peaking over here, so just the thing that was really low was probably the music for a little while there, but that was me doing that on purpose. But definitely yell at me if this is somehow the volume is way too low, because like I said, I'm peaking over here. Great, thank you. Let me get my documents up for the next story here. We'll talk about Martin Shkreli. Oh, I think I already had him. So it turns out that Martin Shkreli is not done with the Department of Justice. The prosecution writes to Judge Matsumoto, Dear Judge Matsumoto, the United States respectfully submits this letter, along with the attached summary charts and declaration of FBI Special Agent Sean Sweeney, dated November 30th, 2017, the declaration, in support of its post-trial motion for forfeiture against the convict defendant Martin Shkreli. By this motion, the government seeks forfeiture of the following amounts: $3 million based on Shkreli's conviction on count 3, securities fraud; $3.4 million based on Shkreli's conviction on count 6, securities fraud; and $960,000 based on Shkreli's conviction on count 8, conspiracy to commit securities fraud. The court should hold Shkreli financially accountable for his criminal conduct by requiring him to forfeit the amounts above, which total $7.4 million, and enter a forfeiture money judgment against him in that total amount. As set forth herein, this total amount represents a conservative computation of the proceeds Shkreli personally obtained as a result of his 3 different securities fraud crimes of conviction. Furthermore, the government seeks forfeiture of certain substitute assets of Shkreli in order to partially satisfy the forfeiture money judgment. For the court's convenience, a proposed preliminary order of forfeiture is also included with this submission, which the United States respectfully requests be entered by the court. On or about June 3rd, a superseding indictment against Skrelly was returned, which included criminal forfeiture allegations. On August 4th, following a 6-week trial, Skrelly was convicted of counts 3, 6, and 8. Before the jury deliberated on the substantive criminal charges, the parties stipulated to waive any right to a jury and have the forfeiture allegations determined by the court. Rule 32.2 of the Federal Rules of Criminal Procedure govern the criminal forfeiture sought by the government in this case. In pertinent part, as soon as practicable after a verdict of guilty on any count in an indictment regarding which criminal forfeiture is sought, the court must determine what property is subject to forfeiture under the applicable statute. If the government seeks forfeiture of specific property, the court must determine whether the government has established the requisite nexus between the property and the offense. If the government seeks a personal money judgment, the court must determine the amount of money the defendant will be ordered to pay. Further, in pertinent part, Rule 32.2b1b provides the court's determination may be based on evidence already in the record and on any additional evidence or information submitted by the parties and accepted by the court as relevant and reliable. Here, the government seeks forfeiture pursuant to the following forfeiture statutes: 18 U.S.C. 981, 28 U.S.C. 2461, and 21 U.S.C. 853. Title 18 U.S.C. 981 specifically provides for forfeiture of any real personal property which constitutes or is derived from the proceeds traceable to any offense constituting specified unlawful activity, or a conspiracy to commit such offense. Fraud in the sale of securities or conspiracy to commit securities fraud are each unlawful activities as defined by the statute. Further, the Second Circuit has held in the context of insider trading security fraud cases, the applicable definition of proceeds is set forth in 981 as follows. In cases involving lawful goods or lawful services that are sold or provided in an illegal manner, the term proceeds means the amount of money acquired through the illegal transactions resulting in the forfeiture, less the direct costs incurred in providing the goods or services. In contrast to the guilt phase of the criminal trial, the government bears the burden of proof of establishing the amount of money subject to forfeiture only by preponderance of the evidence. So, different standard of proof for the government when it comes to a forfeiture versus a criminal conviction. It's no longer beyond a reasonable doubt. Now it's preponderance of the evidence, which I liken to a tug of war at the 50-yard line, and whoever gets the center of the rope into their side of the field wins. It's no longer it's no longer an end zone after 50 yards. It's the whole thing is the end zone. So it's just a tug of war at the 50-yard line, basically. No one has to seriously convince the court beyond a reasonable doubt. It's just convincing the court beyond the opposing side's presentation. So that could also be an example for the Alex Mauer situation. We're in a civil case doing the prosecution against Alex Mauer, and the preponderance of the evidence standard is the same standard there, and she decides she doesn't want to defend, so that's pretty convincing, right? We've put on some sort of evidence, and she has decided not to, so who's being more convincing there? Of course, the judge is going to side with the more convincing party. If she had tried to be convincing, the judge would be taking her case seriously right now. The government is not required to provide a precise calculation of the amount of money a defendant must forfeit. In this case, the trial testimony and exhibits established that during the relevant periods of Skrelly's security fraud schemes, Skrelly himself had control of and accessed millions of dollars. As the majority of federal courts have held, a defendant must forfeit those funds he would not have had but for his criminal offenses. As noted above, Skrelly's forfeiture liability should be a total of the following amounts that Skrelly obtained: the amount of funds invested by defrauded investors, the amount of funds invested by defrauded investors in a different, MSMB Capital, MSMB Healthcare, and the funds generated from the Retrofin unrestricted shares transferred to defrauded investors. Each of these components is discussed in detail. We're going to skip this part. Sorry, I'm all stuffed up. Valuation of shares, forfeiture of substitute assets. This is what everybody wants to see here. Pursuant to Federal Rule of Criminal Procedure 32.2e and 21 U.S.C. 853p, the government is entitled to seek the forfeiture of substitute assets from Skrelly up to the value of any forfeiture money judgment that may be imposed. As set forth in the accompanying declaration, diligent efforts have been made to locate traceable assets of Skrelly's security fraud crimes without success. Accordingly, the conditions for forfeiting substitute assets as set forth in the law have been met. Further, as set forth in the accompanying declaration, now that Skrelly has been convicted, substitute assets of his have been located and should be applied to partially satisfy the forfeiture money judgment. Specifically, the following substitute assets owned by Skrelly have to date been identified, and now that Skrelly has been convicted, the court should direct that they be forfeited to the United States in partial satisfaction of his forfeiture money judgment. A. $5 million in cash that is currently held in an E-Trade brokerage account ending in digits 0258 as security for Skrelly's bond, pursuant to the orders of court dated January 7th, 2016, and August 24th, 2016, and October 19th, 2017. B. Skrelly's interest in and the monetary value of any and all shares held in an entity called Turing Pharmaceuticals. So all of his interest in Turing Pharmaceuticals. C. The album Once Upon a Time in Shaolin by the Wu-Tang Clan, as well as any proceeds derived from the sale of such album. D. The album The Carter 5 by Lil Wayne, as well as any proceeds derived from the sale of such album. E. An Enigma machine, as well as the proceeds derived from the sale of such machine. And F. A Picasso painting, as well as any proceeds derived from the sale of such painting. Preservation of assets is necessary in order to ensure that the forfeiture money judgment is collectible and satisfied by Skrelly, and pursuant to this court broad authority under Federal Rule Criminal Procedure 32.2 B3. United States respectfully requests that the proposed preliminary order of forfeiture also include provisions to ensure that the value of the substitute assets and any funds to satisfy the forfeiture judgment are preserved for criminal forfeiture and pending any appeal. Asset preservation is particularly critical in this case now that Skrelly has been convicted and the United States seeks a significant forfeiture money judgment against him. Conclusion. For the reasons set forth below, the government respectfully requests that the court impose against defendant Skrelly a forfeiture money judgment in the amount of $7.4 million. Further, in partial satisfaction, the government respectfully requests the court order Skrelly to forfeit the substitute assets listed. The government respectfully requests that the enclosed proposed preliminary order of forfeiture be entered and attached to his judgment and conviction pursuant to the law. Respectfully submitted, Bridget M. Road, Acting United States Attorney. What do you think of that? So he has an Enigma machine as well as 2 albums and a Picasso painting. So he thought he was such hot shit. It turns out it's just a big liar. Let's go over this other one. Epic has settled one of the cases against the cheaters. This really is pretty hot. You're just jealous. Yeah. I don't know. I never really... I don't... Why would you be attracted to... No. Not you. I don't mean you specifically. I personally find that people who have means and still act like that, to be like even more distasteful. I don't know. Is that wrong of me? I don't think so. I'm pretty sure. Like I fight pretty hard with a little bit of money I have. I basically like bounce from back and forth from poverty from time to time, and so it's just I don't have a lot of sympathy for people who have a crap ton of money and then still feel like they have to lie to obtain more of it. Even Kate can't tell if she's trolling, if they're trolling or not.
I mean, I wish I had $7.4 million.
Yeah, I would say give me $7.4 million and I'll show you how not corrupt I am. Like, really? We'll use it for good.
I'm a simple man.
Okay. Next, I thought we'd go over the cheater thing. Where did it go? There is a settlement in one of the... Oh, right, I didn't bring it up. Let me bring it up. Stop that. Of course, I closed Twitter, so now it's going to come through on my phone. Stop that. The instant I closed it, it came through on my phone. Okay, so now I've seen... Let's bring this up first. Okay, yeah, this will be good. I think you guys will enjoy this. Bear with me for a second. Close that. And here is the order. Okay, so that's the same thing I just downloaded. Thanks, guys. We'll go over one of them. Page for both of them. Okay, so there's a couple updates in the Epic Games versus cheater cases that have been going on. Let's take a look at some of this. Here in the United States District Court for the Eastern District of North Carolina, Plaintiff Epic Games and defendant Charles Vraspear have reached an agreement to settle the dispute between them, including without limitation the above captioned action, and as part of the settlement between them stipulate to the entry of this permanent injunction. This court has proper jurisdiction over the subject matter. This court has personal jurisdiction venue. Yeah. Permanent injunction and order. Based on the parties' stipulation and agreement hereto, it is hereby ordered adjudged decreed as follows. Defendant Charles Vraspear, along with his agents, representatives, partners, joint venturers, etc., are permanently enjoined and restrained from infringing any of Epic's currently existing or future copyrighted works, including without limitation infringement by the use of any software or device that copies or modifies Epic's software in violation of the Copyright Act, from creating, writing, developing, advertising, promoting, or distributing anything that infringes Epic's works now or hereafter protected by any of Epic's copyrights, from inducing or materially contributing to the direct infringement of any of Epic's currently existing or future copyrighted works by others, including without limitation infringement by the use of software device that copies or modifies Epic's software in violation of the Copyright Act, from violating Epic's terms of service, from violating Epic's end-user license agreement, from intentionally interfering with Epic's contracts or contractual relations, from cheating at any of Epic's games, from materially contributing to cheating by others, to engaging in any activity that creates an infringement of any copyrights, by unfairly competing with Epic in any manner whatsoever, from assisting, aiding, or abetting any other person from performing any of these activities. No bond will be required. Plaintiff and defendant acknowledge that they have knowingly and voluntarily entered into this stipulation. Except as to defendant's obligations, plaintiff's claims against defendants, and any claims that could have been asserted in this action are hereby dismissed with prejudice. This stipulation and permanent injunction is final and may not be appealed. Nothing in this stipulation precludes plaintiff or defendant from asserting any claims or rights that arise after defendant's stipulation. Nothing in this stipulation precludes plaintiff or defendant from asserting any claims or rights against any third party. Defendant waives any objection under the Federal Rules of Civil Procedure, and this court shall retain jurisdiction over the matter to enforce a violation. If any such violation occurs, the court shall award, without regard to proof of actual damages, liquidated damages of $5,000, injunctive relief enjoining any further breach, attorney's fees and costs, and any other such relief as the court deems proper. One note in there, liquidated damages is an important term. Liquidated damages is a determination of damages that the parties reach, and without the judge making a determination of actual damage, it's sort of like an agreed upon punishment. It's not a punishment, though, because this is a contract, and so we can't have punishments for contracts. So instead what we have is an agreed upon damages that should something happen, we expect the damages will be somewhere around $5,000. So we're just going to say 5,000. And the courts usually defer to that number unless that number is wildly out of whack. If this number had been $3 million, the judge will probably have a problem with that. But since the costs of going to court to enforce this are probably closer to $2,000 to $5,000, 5,000 seems like a fine number to me. So that was the first settlement with the epic cheater situation there. What do you think of that? The other thing that happened with the other update was in the Rogers, the Epic Games versus Rogers story, where the mother had written in. I do have a copy of their response, but it's very simple. The Epic Games wrote a letter back explaining that they didn't know at the time that they filed the complaint that the cheater was a child, was a 14-year-old child. And so from now on, they will redact out the cheater's name. They're supposed to use just the initials of minor children. So they then also asked the court for guidance. So that's really it. That's all that's happening there, is they got accused of revealing the child's name, but of course they didn't know that at the time the child had represented that he was an adult online, as so many children can do these days. So let me know if you have any comments about that, or send an ask if you have any questions.
I have a couple of people to thank for subscriptions.
Sure, go ahead.
Thank you to Wild Hufflepuff for the subscription. Thank you to Zero the Nun for a subscription, and thank you to Cakers 1982 for your Twitch Prime subscription.
Yes, thank you all. Kotaku has a pet peeve that he thinks 14-year-olds are not children. I agree that there are technical definitions, but we're just using the loose definition of anyone under 18 is considered a minor child in the law. So there is an update in, or at least a little bit of an update in the Roy Moore situation. This was the Alabama Senate candidate, I think it is, who has been accused of having relationships with pubescent 14-year-old children. And one of the newspapers that has been reporting it is AL.com. And AL.com has been threatened with a lawsuit several times. So this is their response. It's 2 pages, so I figured this will be pretty good to go over. This is from Trenton Garman, Esquire. Response to the November 14th correspondence concerning Roy Moore. Dear Mr. Garman, excuse me, this is written to Trenton Garman. I am writing on behalf of the Alabama Media Group, which publishes AL.com, in response to your November 14th letter. You have now twice threatened to sue AMG and AL.com concerning AL's recent reporting about Roy Moore and their Foundation for Moral Law. You have accused AL.com of making false reports and or careless reporting about multiple subjects related to your clients. Your letter demands that AL.com retract and recant its prior stories and that it cease and desist from any further reporting about your clients. AL.com hereby rejects your demand. AL stands by its reporting regarding all of the matters addressed in your letter. And to the extent that your letter restates the issues that you previously raised in another letter, we will redirect you to our prior response, which we stand by as well. AL.com has reported on newsworthy matters of significant public concern regarding your clients. Roy Moore is now, and for decades has been, a public figure. He is running for a seat in the U.S. Senate. He is asking the people of Alabama to financially support his campaign and his foundation, headed by Mrs. Moore, and to vote for him. Alabamians, for that matter, all Americans, have a right to know about the individuals who wish to represent them in public office. Like every political candidate, Mr. Moore is subject to scrutiny and analysis by the media and the general public regarding his fitness for public office. AL.com's reporting has provided the public with important information directly relevant to that inquiry. You accuse AL.com of defamation in a purely conclusory fashion. You have not explained how anything that AL.com reported is untrue, inaccurate, or erroneous, nor do you provide any support for your position. You also have not shown that AL.com reported any of its stories with actual malice. As you know, you must, because your clients are public figures, a point you have admitted in recent television interviews. To the contrary, even an ever-increasing torrent of accusers and journalist investigators have publicly verified the facts reported by AL.com. Your letter goes on to say that AL.com's reporting has harmed Mr. Moore's reputation. Mr. Moore, however, has quite a colorful past that long preceded any of AL.com's recent coverage of your clients. Moreover, much of that information that you claim harmed Mr. Moore's reputation has already been published by those who know him personally and reported by other media outlets. In other words, any damage to Mr. Moore's reputation was self-inflicted and had already occurred long before AL.com's recent reporting. For these and other reasons, we strongly believe that any lawsuit of the type you threaten would be frivolous and could not be brought in good faith. Should your clients nevertheless wish to pursue this matter further, AL.com will vigorously defend itself and will employ all available remedies, including a Rule 11 motion if warranted. We are confident that litigation would not only demonstrate that AL.com exercised the utmost diligence and employed high journalistic standards in reporting these stories, but would also reveal other important information about your clients. We are hereby putting your clients on notice of their duty to preserve and maintain all materials, documents, writings, recordings, statements, notes, letters, journals, diaries, calendars, emails, photographs, videos, computers, cell phones, electronic data, and other information that is or could remotely be relevant in any manner to any of the claims that you have made. These include, but are not limited to, all materials and information related to Mr. Moore's history of romantic relationships or physical encounters, whether consensual or not, your client's fundraising, compensation, and finances, and Mr. Moore's speaking engagements, travel arrangements, and other expenses. As you know, failure to preserve any such materials may expose your clients to sanctions. If you would like to discuss these matters further, please feel free to contact me. Sincerely, John G. Thompson, Jr., attorneys for AL.com. Lightfoot, Franklin & White, LLC. Very well written. Very, very well written. They threatened them with sanctions, and they threatened them with a discovery proceeding, which is probably even more damaging than anything else, because a discovery proceeding would either result in the turning over of vast quantities of damning documents, or sanctions for not turning that over. So, give that a tumble in your mind. Oh, I totally skipped the Michael Flynn stuff. Let's bring that up. That's next. I don't even know how I did that. And why is it not in here? Where did it go? That's weird. Sorry, guys. I gotta re-download my the documents that I have for the Flynn prosecution. Oh, that's right. I downloaded them on my phone. That's why. There's 3 documents. There's a statement of the offense, there is some kind of information sheet, and then there is a sheet about the actual agreement. So let me open these up here. Open, open, open. I think some of these are a bit too big. There we go. So there's been a huge update in the investigation into improper Russian contacts between the Trump administration and Russian contacts. Sorry. What happened on Friday was Michael Flynn apparently pled guilty to providing false information to the court and to the FBI. Well, to the FBI, I guess. And agreed to cooperate with Robert Mueller's investigation. So we'll go over this 2-page information sheet first. And then there's a 6-page statement of the offense and a 10-page, I don't know what they're calling this, plea agreement. So we'll go over them in that order, and we'll go over them carefully because I think this is really important stuff. This is quite a historical moment in American history. So this is a information sheet. The special counsel informs the court. Count 1, false statements. On or about January 24th, 2017, defendant Michael T. Flynn did willfully and knowingly make materially false, fictitious, and fraudulent statements and representations in a matter within the jurisdiction of the executive branch of the government of the United States, to wit, the defendant falsely stated and represented to agents of the Federal Bureau of Investigation that, on or about December 29th, 2016, defendant did not ask the government of Russia's ambassador to the United States, the Russian ambassador, to refrain from escalating the situation in response to sanctions that the United States had imposed against Russia that same day. And Flynn did not recall the Russian ambassador subsequently telling him that Russia had chosen to moderate its response to those sanctions as a result of his request. On or about December 22nd, Flynn did not ask the Russian ambassador to delay the vote on or defeat a pending United Nations Security Council resolution, and that the Russian ambassador subsequently never described to Flynn Russia's response to his request. So he lied about that, which means he did ask the Russian ambassador to refrain from escalating the situation in response to sanctions, and that the Russian ambassador did tell him that Russia had chosen to moderate its response to those sanctions as a result of his request, and that Flynn did ask the Russian ambassador to delay the vote or defeat a pending UN Security Council resolution, and that he did receive some kind of description or response to that request. So, starting there. Pursuant to Federal Rule of Criminal Procedure 11, the U.S. and the defendant, Michael T. Flynn, stipulate and agree that the following facts are true and accurate. These facts do not constitute all of the facts known to the parties concerning the charged offense. They are being submitted to demonstrate that sufficient facts exist that the defendant committed the offense to which he is pleading guilty. The defendant, Michael T. Flynn, who served as a surrogate and national security advisor for the presidential campaign of Donald J. Trump, the campaign, as a senior member of the President-elect Trump's transition team, the presidential transition team, and as the national security advisor to President Trump, made materially false statements and omissions during an interview with the Federal Bureau of Investigation on January 24, 2017, in Washington, D.C. At the time of the interview, the FBI had opened an investigation into the government of Russia's efforts to interfere in the 2016 presidential election, including the nature of any links between individuals associated with the campaign and Russia, and whether there was any coordination between the campaign and Russia's efforts. Flynn's false statements and omissions impeded and otherwise had a material impact on the FBI's ongoing investigation into the existence of any links or coordination between individuals associated with the campaign and Russia's efforts to interfere with the 2016 presidential election. False statements regarding Flynn's request to the Russian ambassador that Russia refrain from escalating the situation in response to the U.S. sanctions against Russia. On or about January 27, 2017, Flynn agreed to be interviewed by agents from the FBI. During the interview, Flynn falsely stated that he did not ask Russia's ambassador to the U.S. to refrain from escalating the situation in response to sanctions that the U.S. had imposed against Russia. Flynn also falsely stated that he did not remember a follow-up conversation in which the Russian ambassador stated that Russia had chosen to moderate its response to those sanctions as a result of Flynn's request. Remember, some of these sanctions were the Magnitsky Act, the sanctions from the murder of a lawyer who was investigating Russian corruption. So this is a big freaking deal. We're trying to figure out where corrupt people, where criminals are, using legal means, using the system as designed. And Michael Flynn is asking Russia to temper their response to our sanctions. In truth and in fact, however, Flynn then and there knew that the following had occurred. On December 28th, President Barack Obama signed Executive Order 13757, which was to take effect on December 29th. The executive order announced sanctions against Russia in response to the government's actions intended to interfere with the 2016 presidential election. Okay, so those sanctions are the sanctions we're talking about. On or about December 28th, the Russian ambassador contacted Flynn. On or about December 29th, Flynn called a senior official of the presidential transition team, who was with other senior members of the presidential transition team at the Mar-a-Lago resort in Palm Beach, Florida, to discuss what, if anything, to communicate to the Russian ambassador about the U.S. sanctions. On that call, Flynn and the presidential transition team official discussed the U.S. sanctions, including the potential impact of those sanctions on the incoming administration's foreign policy goals. The presidential transition team official and Flynn also discussed that the members of the presidential transition team at Mar-a-Lago did not want Russia to escalate the situation. Immediately after his phone call with the PTT official, Flynn called the Russian ambassador and requested that Russia not escalate the situation and only respond to the U.S. sanctions in a reciprocal manner. Shortly after his phone call with the Russian ambassador, Flynn spoke with the PTT official to report on the substance of his call with the Russian ambassador, including their discussion of U.S. sanctions. On or about December 30th, 2016, Vladimir Putin released a statement indicating that Russia would not take retaliatory measures in response to the U.S. sanctions at that time. On or about December 31st, the Russian ambassador called Flynn and informed him that Russia had chosen not to retaliate in response to Flynn's request. After his phone call with the Russian ambassador, Flynn spoke with senior members of the presidential transition team about Flynn's conversation with the Russian ambassador regarding the U.S. sanctions and Russia's decision not to escalate the situation. False statements regarding Flynn's request that foreign officials vote against or delay a United Nations Security Council resolution. During a January 24th voluntary interview, Flynn made again false statements about calls he made to Russia and several other countries regarding a resolution submitted by Egypt to the UN Security Council on December 21st, 2016. Specifically, Flynn falsely stated that he only asked the countries' positions on the vote, that he did not request any of the countries take a particular action on the resolution, Flynn also falsely stated that the Russian ambassador never described to him Russia's response to Flynn's request regarding the resolution. In truth and in fact, however, Flynn then and there knew the following had occurred. On or about December 21st, 2016, Egypt submitted a resolution to the UN Security Council on the issue of Israeli settlements. The UN Security Council was scheduled to vote on the resolution the following day. On or about December 22nd, 2016, a very senior member of the presidential transition team directed Flynn to contact officials from foreign governments, including Russia, to learn where each government stood on the resolution and to influence those governments to delay the vote and defeat the resolution. On or about December 22nd, 2016, Flynn contacted the Russian ambassador about the pending vote. Flynn informed the Russian ambassador about the incoming administration's opposition to the resolution and requested that Russia vote against or delay the resolution. On or about December 23, 2016, Flynn again spoke with the Russian ambassador, who informed Flynn that if it came to a vote, Russia would not vote against the resolution. Other false statements regarding Flynn's contact with foreign governments. On March 7, 2017, Flynn filed multiple documents with the Department of Justice pursuant to the Foreign Agents Registration Act pertaining to a project performed by him and his company, the Flynn Intel Group, for the principal benefit of the Republic of Turkey. In the FARA filings, Flynn made materially false statements and omissions, including falsely stating that FIG did not know whether or the extent to which the Republic of Turkey was involved in the Turkey project. The Turkey project was focusing on improving U.S. business organizations' confidence regarding doing business in Turkey, and C, an op-ed by Flynn published in The Hill on November 8, 2016, was written at his own initiative and by omitting that officials from the Republic of Turkey provided supervision and direction over the Turkey project. The preceding statement is a summary made for the purposes of providing the court with a factual basis for Michael Flynn, my guilty plea to the charge against me. It does not include all the facts known to me regarding this offense. I make this statement knowingly and voluntarily, and because I am in fact guilty of the crime charged. No threats have been made to me, nor am I under the influence of anything that could impede my ability to understand this statement. I have read every word of this statement. I have had it read to me, pursuant to Federal Rule of Criminal Procedure 11, and after consulting with my attorneys, I agree and stipulate to the statement of offense and declare under penalty of perjury that it is true and correct. Signed November 30th, Michael T. Flynn, defendant. I really want to know who the high-ranking presidential transition team official is. But let's now go to his plea agreement and read his plea agreement. Dear Counsel, this letter sets forth the full and complete plea offer that your client, Lieutenant General Michael T. Flynn, retired, hereinafter referred to as your client or defendant, from the Special Counsel's office, the government, or this office. If your client accepts the terms and conditions of this offer, please have your client execute this document in the space provided below. Your client agrees to plead guilty to the criminal information, a copy of which is attached. Your client understands that a violation carries a maximum sentence of 5 years in prison, a fine of $250,000, a term of supervised release of not more than 3 years, and an obligation to pay an applicable interest or penalties on fines and restitution not timely made. In addition, your client agrees to pay a special assessment of $100 per felony conviction to the clerk of the U.S. District Court for D.C. Your client also understands that, according to sentencing guidelines, the court may impose a fine that is sufficient to pay the federal government the costs of any imprisonment, terms of supervised release, or period of probation. Your client agrees to the attached statement of offense. In consideration of your client's guilty plea, your client will not be further prosecuted criminally by this office for the conduct set forth in the attached statement of the offense. Sentencing guidelines, they do a sentencing guidelines analysis here. Your client understands that the sentence in this case will be determined by the court pursuant to Federal Rule of Criminal Procedure 11, and to assist the court in determining, the parties agree to the following: that the sentencing guidelines sections apply, a base level offense of 6. The government agrees to a 2-level reduction will be appropriate, and this is all with the sentencing guidelines. You have various levels, and it's sort of like a score, and the score determines what level of of sentencing you should be subject to. Based on the information now available to this office, your client has no prior criminal convictions. Accordingly, your client is estimated to have 0 criminal history points, and thus the criminal history category is estimated to be 1. Estimated applicable guidelines range. At guidelines level 4, the estimated fine is $500 to $9,500. Your client reserves the right to ask the court not to impose any fine. Your client's estimated sentencing guidelines range for incarceration is 0 months to 6 months imprisonment. The parties agree that solely for the purposes of calculating the applicable range under the sentencing guidelines, neither a downward nor upward departure from the estimated guidelines is warranted. Your client acknowledges and understands that these sections apply only to conduct that occurred before the execution of this agreement. Further sentencing stuff. Your client understands that the sentence in this case will be imposed in accordance with the law upon consideration of the guidelines. Your client further understands the sentence to be imposed is a matter solely within the discretion of the court. So the court could decide not to allow this. Cooperation. Your client agrees to cooperate with this office on the following terms and conditions. Your client shall cooperate fully, truthfully, completely, and forthrightly with this office and any other federal, state, local law enforcement authorities identified by this office in any and all matters as to which this office deems the cooperation relevant. Your client acknowledges that your client's cooperation may include, but will not necessarily be limited to, answering questions, providing sworn written statements, taking government administered polygraphs, and participating in covert law enforcement activities. So he agrees to spy if he has to. Any refusal by your client to cooperate will be deemed by this office as a breach of this agreement by your client and will relieve this office of its obligations under this agreement. Your client shall promptly turn over to this office any and all evidence of crimes about which your client is aware. Your client will submit a full and complete accounting of your client's financial assets. Your client acknowledges and understands during the course of cooperation, your client will be interviewed by law enforcement or attorneys. Your client waives all rights in regards to that. Your client shall testify fully, completely, and truthfully before any and all grand juries in the D.C. And elsewhere. Your client understands and acknowledges that nothing in this agreement allows your client to commit any criminal violation. Your client agrees to the sentencing in this case may be delayed until your client's efforts to cooperate have been completed, so that the court will have the benefit of all relevant information before a sentence is imposed. You waive any challenge to venue. You waive any challenge to the statute of limitations. You waive trial rights. You waive appeal rights. You waive collateral attack rights. You waive Privacy Act and Freedom of Information Act rights. Your client understands the court has an obligation to determine if restitution applies. The government and your client agree that restitution does not apply in this case. Your client understands and agrees that if after entering this agreement your client fails specifically to perform or fulfill each and every one of your client's obligations under this agreement, the government will be free from its obligations. Your client will not have the right to withdraw the guilty plea. Your client will be fully subject to criminal prosecution for other crimes. The government will be free to use your client directly and indirectly in any civil prosecution, all statements made by your client, etc. Your client understands and agrees the government shall be required to prove a breach of this agreement only by preponderance of the evidence, and nothing in this agreement shall be construed to permit your client to commit perjury or otherwise make any false statements. The government will bring to the court's attention at the time of sentencing the nature and extent of your client's cooperation, and no other agreements, promises, understandings have been made outside of this agreement. Signed, Robert S. Mueller III, Special Counsel. Defendant says he has read every page of this agreement, fully understands it, pleading guilty because he is in fact guilty. Signed, Lieutenant General Michael T. Flynn, Defendant. What do you think of that? That has even more information in it than I had heard in the news stories. It sounds to me like he really did act way outside of the president-elect's authority. who does not become the president, who does not have diplomatic authority until January 20th of 2017. So that seems to me to be quite an egregious violation of the law. And we'll see what happens here. It seems like there's a reference to a higher presidential transition team official. Whether that's the president or not, I don't know. So we'll keep an eye on that, and we'll share whatever happens with that with you. What do you think of that? That's a pretty big deal that I think we just read there.
That sounds like a big deal.
Yeah. So, and then having done that is one thing, and then having lied about it is another thing. Let's see. We read the Roy Moore letter. We read the Epic thing. It's been an hour. We could go over the qualified immunity case. We'll go over the qualified immunity case real quick here. It's 80 pages, but we're not going over all 80 pages. We're just going to go over the summary.
Really fast. 2 people to thank for subscriptions. Yes. Starblazer
Please.
Subscribed to Twitch Prime. Thank you very much. Cinderflame subscribed. Thank you to Mistax8 for cheering 100 bits. This has got to be the biggest S show in the U.S. government I've ever been alive to see.
Yeah, I agree. It's not. I'm really not just trying to get down on Republicans or anything like that. I'm not against Republican values. I mean, for example, I shoot guns. I happen to believe in Second Amendment rights. I believe in actual Second Amendment rights. Maybe background checks on things are good. We don't have to get into the details of it, but what I mean is that I'm not against there being politics, and I mean, it's the extreme politics, it's the misrepresentations, it's the lying, it's the cheating, it's the obstructionist on both sides politics that really bothers me. We don't get work done in work this way. We don't get work done at school this way. We don't get work done at the channel this way. Nobody else in the entire world operates this way, but yet politicians work this way. So, or rather, it seems, doesn't work this way. So I'm all for getting corruption out of politics. And so what you're going to see from me is attacking the system in general. And it just happens to be a Trump administration, happens to be a Republican administration right now. So that's what I'm attacking. If it was if Barack Obama if any of this had happened and it had been Barack Obama, I would be just as upset, if not even more upset, because that was the person that I thought was the proper candidate at the time. I did not vote for Trump because I did not think that he was even close to presidential, and to me this sort of confirms that. But I'm not here on this channel for confirmation bias of my political views. I'm here to look at the law, and so that's what we're going to look at. I'm more than willing to admit my personal biases, but I really am a pretty moderate person who just wants to see the tools that we have used for the benefit of society, not any one person or one organization or group or anything like that. It's supposed to be a representative democracy, and it's supposed to be a government for the people, by the people, not the other way around. And it seems like our government at times does a really good job of trying to claw power back from the people and keep the people at arm's length. And that's what I'm not for. Whether it's Republican, Democrat, Independent, Green Party, whatever. I am not for a government that doesn't need to worry about the will of its people. Rant over. Anything else, Brandon? I'll finish up with this last
quick
case
question.
thing.
Yasu Gimal, sorry about that. Yasuki Humal asks, is it normal for the government to ask for certain items to be sold in order to pay for fines that were incurred?
Yes, that was the section that we read where they said that the law says that in certain circumstances you can ask for that stuff. So yeah, they're for the amount of money and the likelihood that the defendant will not pay it, the government is asking that these assets be, 1, preserved, and 2, turned over to the government for sale. So then the government will hold an auction, someone will buy those things, now a new person will own those things, and the money will go to the government to reimburse the government and the investors who lost their money because of Skrelly's lies and fraud. Other questions?
Pretty much everything that was asked, you've covered. So.
Okay. So for our last story here, this is a petition for writ of certiorari, which when we see that, we know it's an appeal to the Supreme Court of the United States. And in order to get to the Supreme Court, there's only so many things that you can, only so many ways you can get there. So most of the time we're appealing from a U.S. Court of Appeals. In this case, we're appealing from the decision of the U.S. Court of Appeals for the 10th Circuit. This is Marianne Soze. I'm going to say it's Soze, whether it's Soze or not. You know, Kaiser Soze, she's Kaiser Soze's wife. We're going to pretend. No, I'm kidding. We shouldn't do that. Mix the law and fact and pretend. But I'm still going to pronounce it Soze. Versus Timothy Bauer. Timothy Bauer. Questions presented. Law enforcement officers stopped Marianne Soze from praying silently in her home. Wait, what? Law enforcement officers stopped her from praying silently in her home, not to further any legitimate law enforcement interest, but so they could harass her. The 10th Circuit correctly assumed this conduct violated Soze's rights under the First Amendment. Yet they nevertheless granted qualified immunity to the officers, solely on the ground that their alleged conduct was so obviously unconstitutional that there is no prior case law involving similar facts. They granted qualified immunity because Soze doesn't identify a single case in which this court, or any other court for that matter, has already found a First Amendment violation based on a factual scenario even remotely resembling the one we encounter here. The question then is, does the 10th Circuit holding conflict with Hope v. Pelzer, which expressly rejected a requirement that previous cases be fundamentally similar or involve materially similar facts? Does this error warrant summary relief? Petitioner Marianne Soze, who was the plaintiff appellate in the 10th Circuit, and respondents are the defendant appellees. Timothy Bauer is the chief of police of Lewisburg, Kansas. And we're just going to go through the summary real quick here, which I think there is one. This case presents one simple question. Would a reasonable police officer have known that forcing a citizen to stop praying silently in her home, absent any legitimate justification whatsoever, violated the First Amendment? To ask the question is to answer it. The principle that government may not suppress religious or belief or practice is so well understood that few violations are recorded in our opinions. Yet that is precisely what Ms. Soze alleged in her complaint. Officers Stevens and Lindsay were at her home while investigating a noise complaint. They told her that the Constitution and the Bill of Rights were nothing, just a piece of paper that doesn't work here, and that she was going to jail, and although they did not know why she would be going to jail, that her bond would be $2,000. Understandably frightened by the officer's obviously unprofessional conduct, Ms. Soze sought and received permission to pray. The officers then interrupted their investigation, demanded that she get up and stop praying, only to tell her that she needed to move from here, to move back where she came from because no one liked her here. Lest there be any doubt, issuing that command did nothing to further their investigation. They ordered her to stop praying so they could harass her, according to the court. Ms. Soze's allegations are inconsistent with any legitimate law enforcement purpose. The 10th Circuit nevertheless ruled that the officers were entitled to qualified immunity, which protects them from lawsuits, because their alleged conduct was so unconstitutional that no court had ever seen it before, that no court had found a First Amendment violation based on a factual scenario remotely resembling the one we encounter here. In doing so, the 10th Circuit fundamentally misapprehended not only this court's qualified immunity jurisprudence, but the very purpose of qualified immunity itself. As this court has explained, qualified immunity operates to ensure that before they are subjected to suit, officers are on notice their conduct is unlawful. Accordingly, officers can still be on notice that their conduct violates established law even in novel factual circumstances. Quoting Hope v. Peltzer at 741, rejecting the requirement that previous cases be fundamentally similar or have materially similar facts. The 10th Circuit made two key rulings that, taken together, demonstrate that qualified immunity was not warranted. First, it was clearly established that Ms. Soze had a right to pray in the privacy of her home, free from governmental interference, at least in the absence of any legitimate law enforcement interest. Second, that the officers ordered her to stop praying so they could harass her. The command did nothing to further their investigation. These are findings of the 10th Circuit. The 10th Circuit has established these two things already. In other words, the 10th Circuit's own opinion demonstrates that the officers had fair warning that the conduct was unlawful to interfere with Ms. Soze's prayer absent some legitimate law enforcement interest, and that, according to Ms. Soze's allegations, the officers did precisely that. The salient question is whether the state of the law at the time of an incident provided fair warning to the defendants that their alleged conduct was unconstitutional. This fundamental misapprehension of the court's qualified immunity jurisprudence warrants the special remedy of summary reversal. Alternatively, the court should grant the petition for a writ of certiorari and set the case for briefing and reverse. And that's where we'll stop with that one. But that is quite an interesting story. It sounds like the officers were there for a noise complaint. She thought she was going to get in a lot of trouble, and so she asked for permission to pray. They gave her permission to pray, and then while she's praying, they interrupted her, even though there was no lawful purpose to interrupting her prayer. It sounds like she wasn't the one who was guilty of any crime, and that there was no further crime being committed, and so really all they had to do was move on, and instead they stood there and harassed her and insulted her. So that's pretty terrible. But the 10th Circuit said that you can't sue those officers for that, and I think that's wrong. I think that's very clear. The 10th Circuit is quite wrong. The officers were clearly violating her rights, and they should have known that they were clearly violating her rights. There's really no excuse for that. So what do you think of that? That's pretty insane. Do we have any announcements or questions? Otherwise, that's our Sunday show, and that's all I have for you this morning. Did we lose? Oh, we didn't lose Brandon. Amazing.
I'm not seeing anything new.
I see a 13-bit donation from Kate.
Yeah.
Thank you, Kate. Kate likes to donate odd numbers.
Yeah, I was about to mention.
Like 1. I am not going to jump straight into Twitch streaming or game streaming today, but maybe a little bit later this afternoon.
Oh, what about the Do Not Resuscitate tattoo?
Oh, we skipped that one. How in the world did we skip that one? Let's definitely do that.
Unsure.
I don't know how we did that, how we skipped that. Maybe because it's Firefox. So, for what will end up being our final story today, we have this story out of Miami. Now, this is on Science Alert, and I'm trying not to commit copyright infringement, so let's definitely talk about all of the legal commentary and all that. But here is I think this is an actual picture of the tattoo, and this blurred out section is a signature. There was a signature on this tattoo. Doctors in Miami faced an unusual ethical dilemma when an unconscious and failing patient was brought into the emergency room with "Do Not Resuscitate" across his chest. 70-year-old man was taken to the hospital. He had no next of kin that could immediately be found. He had the "Do Not Resuscitate," and it was signed there. What they ended up figuring out was that this was not enough. This did not meet the requirements for Florida's do not resuscitate orders, which have to be in writing. And so they did give the man intravenous fluids and antibiotics and blood pressure medication to buy themselves more time. He couldn't respond to them. He eventually did die after they did find his actual paperwork. He was never publicly identified, so no one knows exactly who it was. But how about that? Just because you write the words "Do not resuscitate" on your chest in tattoo ink and sign it in tattoo ink, which I'm assuming is not your signature, is like a copy of your signature made by your tattoo artist. It's a writing, but it's not the legally recognized writing under the state law to recognize that. For example, here in Pennsylvania, I have requirements as to how I can create a healthcare directive to be recognized by a court. So maybe you should put "Do not resuscitate, see paperwork," and then provide the location of your paperwork. That would be the best option, because your paperwork then needs to be in order. Maybe your paperwork should be on you in your wallet, or in order, in it's on file with the hospital or something, or with your doctor or your lawyer or something, and that person's contact information should be tattooed with you. Maybe instead of a tattoo, it should be a necklace, or I've seen the bracelet with the information on it, very much like you would put on a dog's collar or whatever. It's what you want to do when you find this person and they can't communicate for themselves. I'm not comparing them to a dog. I'm saying that a dog can't communicate. Hey, I belong to Len. Here's his phone number. So if you are doing that for yourself, it's the same principle. You wear dog tags, and you put on your dog tags how to contact your next of kin, or where you find your "Do not resuscitate" paperwork. Or maybe you have to have, maybe it's a little, maybe your necklace or your dog tags have a little piece of paper in there with the "Do not resuscitate" order on it, folded up or something. That's what you would have to do.
Yeah, but a tattoo definitely is not enough information, I would say, right?
Tactical makes a good point, though. A tattoo by itself, while not being enough information, is enough to confuse medical professionals and could make all sorts of complications for you. So make sure it's either a tattoo that says everything you should, or don't get a tattoo. Use a bracelet or something with everything on it. So very, very interesting there. Sorry to hear the man died, but it sounds like he wanted to go. When this happened to him, it sounds like these were his wishes.
Well,
so
the other thing is, it could have
peace.
just been a joke, like.
Well, that's what they were afraid of. What if somebody got that tattooed as a joke in a drunken stupor or something, and then just hadn't gotten around to getting it removed? But in this case, the tattoo did line up with his written wishes. They just hadn't found his written wishes in time.
Okay. Now, what if like a tattoo parlor is offering something like that, hypothetically, is offering that as a tattoo? Would that mean that the tattoo parlor is liable for any damages that might be caused, up to and including death? Like,
I don't know about, wrongful death, because you got to. I would say there's a big legal conundrum there. You have something called assumption of the risk, meaning that he's taking the risk that it could be read the wrong way when he has that tattooed on himself. But yeah, that doesn't mean that you couldn't have a wrongful death lawsuit and hope that, and some plaintiff is hoping that the tattoo parlor either has money or an insurance that will pay out instead of defending a case. Yeah, that happens probably more often than I'd care to admit.
very interesting stuff.
So that's very interesting. Do we have any questions from anyone? I saw a couple questions go by. What is everything that should be included? That's going to be something that's up to your state law or country's law, sale and value. It's not something that I could give you here. That would be considered me giving you legal advice, and I'm not qualified to do that. But most of the time, it's documentation requirements, that it be in a certain form, that it have certain acknowledgments or waivers, or so that the person reading it and signing it has to read all this stuff. So you can say, sure, you can say in a piece of paper, I don't want to be resuscitated under any condition, signed Leonard French. But does that mean that I got all the information that I was supposed to get before I signed that and made that decision? No. So a state may say, you have to have these 2 pages of information beforehand and include that in the DNR, so that we know that the person who signed it at least had access to that, under what conditions they want to be resuscitated, and exactly how medical technology works and all that. Whatever your state says that's what you have to comply with. If you can get all that somehow into a tattoo, great. I don't think you can. I think you can get a reference on the tattoo to that document, and then keep that document in your wallet with your wife or your boyfriend or your husband or your safe deposit box, or on file with your local police department or your local physician, all of the above. I'm not sure that the police or hospital want to keep those things on file, so maybe they won't let you, but you can call them and find out where you should keep those things on file for your area or whatever. Where will they reference when you come to their hospital? They'll probably have a vested interest in you coming to their hospital, and they'll want to help you. Usually there's more than one hospital that you can choose from. So that's the show. Yeah, get a QR code as a tattoo. There you go. That should work.
Yeah, that actually sounds pretty good.
We'll take us out with a little bit of AGST. What do you think? It has been another great week. I'll be doing the Disney versus Redbox case as well this week. Thought maybe I would cover that this morning, but there's just too much to talk about. And this one's really interesting. You know how you get the DVDs or Blu-rays and they come with a digital code these days where you can get a ultraviolet copy or an iTunes copy or a Google Play copy of the movie digitally for free with your purchase. Usually you even have to pay for it. It's a $19.99 copy instead of a $13 copy or something. Well, Redbox has been selling those digital copies. So Disney sued them. And we're going to go over that sometime this week. I also have the Milwaukee versus Snap-on tool battery case thing that I have to get out for AVE, thanks to him. Thank you to DJ Gilcrease for sponsoring a video in the month of December. And thank you to my $50 plus supporters for December: John Steele, Lydia, Collinson, Westin, Lohne, Gavin, Barnard, the Godslain, and Sean McNamara. The rest of you are scrolling on my LED panel behind me and will be in the description of the VODs that I put out from this video. So I really, really appreciate you all. You are keeping this going. You are paying me basically a small wage here to produce these videos full-time. And now that the Imagos case is hopefully done and the vast majority of all of my other work is done, I am focusing on producing content for you full-time. And maybe in the new year we'll even work on making this into a charity type of thing, so that you can get tax deductions for your donations and I can get student loan forgiveness eventually. It's a really great symbiotic system that could all work if we just keep going. So thank you all. Donate to me on Patreon if you aren't already a supporter. Subscribe to me on YouTube. Subscribe to me here if you'd like. All your support is greatly appreciated. I'm Leonard French, your favorite copyright attorney, and I will see you in my videos this week. Have a happy holiday season with you and yours, and I hope everybody is safe, and best wishes and drive safe and all that. I love you all. I'll see if I can get dogs.
Hello everyone, this is Radio Brandon. I'm feeling a bit sick today, so sorry about my husky voice, but how are you all doing? Doing good? That's good. This is the Brandon Takeover minute, where I get to just tell you how much I love you. It's good stuff. Okay, bye.
Nico. How are you, my puppy? Let me throw a video capture device in here. Nope, wrong one. You don't like to come up. I know. Come here. I know you don't like it. I know. There you go. He's a good boy. He's a good boy. He's a good boy.
Cinderflame says, "Get me the dogs, lawyer."
Ilsa. Here she comes. Hello. You're so dark. No one can see you.
Not Ilsa's fault.
Hi.
That's down, Ilsa.
Ilsa, can you come up? Ilsa, up. Go, girl. Oh, hi. You wanted to kiss me, huh? Here. Oh, you don't want a chip? Here, have a chip. That was very nice. Very nice. Oh, now I can't see. Oh, hi.
If somebody was asking for Freebird, so Freebird, you can't actually play it, right? Because copyright reasons.
Probably not. You want to get down? Okay. All right. That was the dogs. There are the dogs. So there you go.
Cool.
So thank you everyone for joining me, and I'll see you this week. Love you all. I'm Leonard French, your favorite copyright attorney. Bye.